In this lesson, what I want to do is talk about the concept of estates in land. Now, we're going to essentially take an overview to the different kinds of estates which can exist within land law, in English law specifically. And the aim here is not necessarily to provide the context and detail of the various elements of conveyancing of estates and the concept of third-party rights over particular pieces of land and all these different things. Of course, those are the things that are going to make up the majority of our subject lessons when we look at unregistered and registered land as well as leases. Instead, we're going to just take an overview so we have a better holistic understanding of what kind of estates in land exist, so that when we go into looking at the more complicated details of land law, we're going to have a better understanding using this lesson of whereabouts we are in terms of our understanding of estates. It's part of the final of our introductory set of lessons on land law and the nature of land ownership, and it's essentially going to talk about the different kinds of estates. So we're going to draw mostly our attention to the concept of the freehold estate in this series of lessons, and we'll talk a little bit about the leasehold at the end of this video, but of course the leasehold and the concept of leases is going to be a separate series of lessons in and of itself. So the first question is, well, what actually is an estate? Estates are the most important area of land law in the sort of modern context of the way in which we study. And an estate is simply an indication as to the period of time which a person is able to hold the land, is able to say that they have possession of the property. And so, as a result of which, the types of estates would change from the common law with the enactment of the Law of Property Act of 1925, the LPA. And ultimately, we can think about a delineation between two major types of estate. You have, firstly, the freehold estate, and then you have, secondly, the concept of the leasehold estate. Within this, you have various different kinds of freehold estates, which we're going to get to in a second. And then, obviously, the leasehold estate, again, refers to a different amount of time for which you have the ability to claim exclusive possession over a piece of property. So beginning first then with the freehold estate, should I say, the freehold estate provides the most substantive rights of ownership in land. So if you have access to a freehold estate, whichever one that we're going to look at in this lesson, you have quite substantial rights over that particular property. We can divide the freehold into three major types of freehold. For the most part, when we talk about land law in future lessons, when we talk about registered and unregistered land, for example, we're going to be focusing almost all of our attention on the concept of the fee simple. That says free simple. On the fee simple. But we will touch on in this lesson what a life estate is and what a fee tail estate is as well. So the fee simple is effectively the absolute ownership of the land in question. So we say obviously that in theory we know that that land is owned by the crown, through the concept of tenure and all these different things like that. But in reality, if you have a fee simple over a piece of land, you are effectively the sole and absolute owner of that land in question. It has the theoretical application of basically allowing you to have an estate indefinitely for as long as you want, and to pass that down for however long you want. And it therefore means that you are de facto the owner of the property. So even though we say and we like to qualify the fact that actually technically the land is owned by the crown, if you're the owner of a fee simple estate, you are basically the owner of that property for the most part. The crown isn't going to be able to just take that land from you. There are only a few circumstances where the law recognizes the true reality of the concept of the fee simple, i.e. that all land is technically owned by the crown. So there are a few examples and there are a few circumstances where the reality of the fact that it is owned by the crown actually plays a little bit of a part. So one of the examples of this is if an individual was to die intestate without any statutory next of kin, then the land returns to the crown bona vacantia, which essentially just means that land that is not owned by anybody. If somebody dies intestate, that means that they die without a will, essentially. Okay, so This is one of the only examples where we can see the influence of the crown and the crown ownership of a fee simple actually play a role in the possession of land ownership. So that's essentially one of the examples that we have here. We'll get onto this in future lessons time when we start to look at the law of succession and the concept of wills and estates. But for now, that is essentially the concept of bona vacantia. The life estate is relatively common, but is one that ultimately entitles one to the ownership of an estate for the duration of an individual's life. So whereas the fee simple allows you to have the ownership of an estate indefinitely for however long you want, the life estate entitles you to ownership for the duration of your life. And it technically means that you are more limited with the life estate than you are with the fee simple. But in terms of actually how this feels for an individual owner, it is still for the rest of your life. And so as a result of which you still have essentially exclusive and indefinite ownership of the estate, because when you die, it doesn't actually matter what happens to the estate, for you at least, but for everybody else it matters. But for the most part, the life estate is a little bit rarer than the concept of the fee simple. It does still exist in some circumstances, but for the most part, when we talk about the concept of freehold ownership, we are talking about the fee simple. Finally, then, we have the very rare fee tail that exists. A fee tail is known as an estate in inheritance, and what the fee tail does is entitle a family ownership so long as there is a continuation of the family lineage. So it essentially means that as soon as the descendants of the original owner dies out, then the fee tail will end. So long as there is an inheritance line that you can trace, and people will still be able to inherit the estate one after the other. That is what the fee tail is. Again, don't really need to spend much time examining it. We just need to, oopsie daisy. We just need to think about it very briefly, and then think about the fee simple in more detail in future lessons. So yeah, increasingly rare in modern land law context, but you can understand how it would be actually more common in a few centuries ago, when the concept of inheritance and the concept of the inheritance of land was a little bit more of an important concept. Finally, then, we have the leasehold. The leasehold essentially will give an individual exclusive possession of the land in question. So in terms of your rights in that land, they're very similar to that of a freehold, but it is only for the duration of a specific period of time, i.e. the duration of the lease. And so ultimately, whereas a freehold gives you potentially lifelong or unlimited access and exclusive possession, the leasehold grants exclusive possession for a limited time period. The leasehold may also grant you a limited ability to do things with the land. So this will obviously be determined by the lease in question, by the terms of the particular contractual lease that exists. But in terms of the duration, it will be the duration of the lease in which you have exclusive possession for it. This is sometimes known as a slice of time. So you are given essentially all of the rights of a freehold in terms of the legal possession of that property, but only for a limited period of time. And so we'll get to this in more detail in future lessons when we actually make a delineation between the leasehold and the freehold, in looking at the definitions of what a lease actually is, the key and the key characteristics and requirements for the existence of a lease, for example.